Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I am here every Sunday from 8 to 9 a.m. on these stations to give landowners valuable information that you need regarding the natural gas development here in Pennsylvania. And of course, this is the show for landowners to make sure we're getting out good quality information for you to be thinking about, and we want to try to even this playing field as much as we can. So, there's some commercials in between here, but the idea primarily is, hey, let's get this information out there. Let's get people thinking. Let's make this information available for the landowners, because I don't know if there's many other resources out there to get this information out. So it's very important that we get this out to you, the landowners. And I've been doing the show since August of 2010. So you can go to pagasleaseattorney.com, go to pipelineattorney.com. A lot of great landowner information there. And also, you can go to YouTube, you can go to iTunes. We post these radio shows. We make them available for everybody for free. You can go to the podcast section of iTunes, type in All Things Marcellus. Go to YouTube, type in All Things Marcellus. We recently started to do the YouTube within the last several months, and I know I've been kind of teasing this, but I promise you, major renovations to the website that I'm very excited about. I've been working weekends, nights, and early mornings, writing the content. Also, in other words, the words, they're going to be on the website. So I'm really excited about that. I'm revamping it. We're going to have a lot of new material available there. One of the things I was working on this past weekend here was the top 10 biggest landowner mistakes that landowners make whenever they're entering into the process. And this was for the gas site at pagasleaseattorney.com. But the same process or same mistakes, a lot of them overlap to the pipelineattorney.com. And I'm going to be doing a top 10 there as well. But I'll tell you, I'm going to have to try to figure out a way to do a new number system, because as I was going through and revamping the site and coming up with some new ideas for this top 10, because one of the things that I've preached before and will continue to preach is, I started the website in 2010, and at that time wrote these top 10 mistakes that people were making, at that time. And a lot of these mistakes continue, and they're the same mistakes that people continue to make today. But one of the big things that a lot of people do not realize is that this market, the gas leasing market, the pipeline market, the market for surface use agreements for roadways, all of these different storage agreements, compressor station agreements, all of these different agreements, the market as far as what a landowner can obtain for compensation, for property protections and addendum terms is constantly changing. And in some cases, it's changing in a positive manner, especially with pipeline agreements and surface and roadway agreements. We're able to do more and more and often get more compensation, sometimes very substantially more compensation. Other times, we can always strengthen these agreements and make them more fair for the landowner. But then also, in the gas leasing is just fascinating, because there are pockets in Pennsylvania where I'm seeing a lot more activity. Other areas have really become silent. And we've had one area in negotiations that I've been working on where the price literally has doubled. We've also seen recently where royalty percentages have gone up in ongoing negotiations. So there are pockets and areas where these numbers are increasing. But you as a landowner must be so careful. Attorneys representing landowners must be so careful to understand where these pockets are, what this means, the benefits, the pitfalls of holding out and pushing. You really need to understand the most complete picture you can when you're making these decisions. And gas leasing, it's something where Back in 2008, 2009, 10, attorneys threw out their shingles. Hey, I do oil and gas law. Hey, I do gas leases, things like that. And at the time, I think that, in my opinion, that representation at that time was so much easier because it was this period of open leasing where companies were just trying to acquire land, trying to acquire leases, because they know, and this is another thing I always preach about. Remember, Pennsylvania isn't the first state. Well, they were the first, but it's not the first state to see this type of activity, to see this type of rush. So these companies know what they're doing. A lot of Pennsylvanians and attorneys don't know. And, this is a first experience. So you're doing the best you can with this. So we got to look and say, okay, we recognize that these companies have gone through this process before. So back in 2008, 9, 10, even into 11, there's this open leasing where there's kind of standards where everybody's kind of getting the standard agreement. If you know what to ask for, you're going to get a better agreement, and it's an easier process. But today is a lot different. It's not that you can go on the internet and type in oil and gas lease addendums and cut and paste and create this addendum and send it to the company. In most cases, the company's going to laugh at you. Maybe not to your face, but it's not the way it is today. In some cases, in some areas, and that's the key to understand those areas, to understand your specific situation, maybe you can get a better agreement. But if you're in an area where the market is really down and you're surrounded by this one single company, and you went online and you found these 10 pages of addendums and you throw them out to the company, they're going to get thrown. The next throw of these addendums is going to be in the garbage. It's not going to happen. Now, that's not to say you don't try, and that's not to say that you can't get very valuable terms in any lease. But representation today and landowner leverage today, the market today, royalty language, interpretation of royalty language, litigation surrounding royalties, those are things which are a lot different. Those things are occurring. There's been a transformation. There's new information. So if you're not involved in this and you're not dealing with this on a constant basis, then you can say, oh, I'm going to go online, or oh, I'm going to talk to somebody, or hey, I'm an attorney. I did a bunch of leases back in 2009. Well, let me tell you, things are completely different today. And before, it used to be you could take the northeastern region of Pennsylvania. You could take the southeastern region. And everybody was kind of in the same situations. Because of competition between the companies, the offers tended to be the same, or one company would jump up maybe a few $100s on a bonus, or $500. Maybe they would add a percentage point or two to the royalty. So that's what you saw. Companies going in step together. One would go higher, the others would come and meet. Today, you can sit there and you can be, great example, take Susquehanna County in northeastern Pennsylvania. You can be in a Cabot area where Cabot is developing and receive a lease offer of $3,500 per acre and 18.75% royalty. Let me tell you, I love Cabot's offer. I have a lot of respect for what Cabot is doing. I really do, as far as the lease offers go. And one thing that I've always said and I'm always going to do is to be honest and say, I do have a lot of respect for them. There's things that Cabot does on the ground with development and like roadways and pads, things like that, which I have problems with how they handle those. But in oil and gas leasing, one of my favorite companies to deal with is Cabot. And I have to say, I have a lot of respect for how they're presenting these leases to people. I have respect for how they're calculating royalties. I know they've had problems. I'm not here to say this certainly is nowhere near commercial for Cabot. If you have any agreement presented by Cabot, especially roadway, well site, you need to call me or somebody else and get some assistance, because there's things they're doing there that I'm not crazy about at all. But you can have an offer from Cabot, $3,500, 18.75%, and you can go right down the road, and sometimes not very far down the road, and you can get an offer from Southwestern at $500 and 15%. And no guarantee by far that they're not going to take deductions and for post-production costs from your royalties. In some cases, they just say, look, we are. Take it or leave it. They're very aggressive in their negotiations. Certainly not one of my favorite companies to deal with lease negotiations, because if they don't have to give it to you, normally they're not going to give it to you. So they run it a lot different fashion than what Cabot does. So if you have a lease offer from Southwestern and you go online and you're looking at all these things and you're looking at these addendum terms or you're hearing these numbers, you need to understand what this market is, and you need to understand what they may be agreeable to. Same thing with Cabot, same thing with Chesapeake, Chief, EOG, Shell, SWEPI, all the companies in out in the southwestern part of the state. We got Range out there. We're doing EQT, all of these different companies. You need to understand the market of your area and what this company is willing to do. And we want to learn from past experience and certainly other people's mistakes. And coming into this, going online, just researching online, you're going to get some bad information. You're going to get information that's not relevant to you. And you need to understand also, where is the source of this information? The source could be a bad source. It could be something that a landman wrote. It could be a bad source because it's somebody that's bitter about this process, and understandably, maybe in their case. But you have to understand that, and you have to understand your region and your market as of today, not as of 2 months ago, as of today. Because if today the numbers have gone up from where they were 2 months ago, you need to take advantage of that, because you're not always going to be told by the landman, oh yeah, we can give you more money. Generally speaking, you're not. So same thing. If the numbers have gone down, you need to understand that too, because you don't want to be in a situation where you're hanging on thinking you're going to get more money and these numbers are going down and you may get left out of production. If you're willing to take that risk, then that is fine. And I respect that, and that's everybody's choice. But what you have to do and what you have to know is, are you taking that risk? There are people who are taking serious risks who don't even know that they are. And that's a concern. You need to understand your situation, because this is evolving quickly and always changing. I am Attorney Doug Clark. This is All Things Marcellus. And I'll finish up the segment. Regular listeners probably know and get bored of it, especially at the beginning. I can hear it here. I got this little scripty thing that I read off of. Well, I don't read off of it, but I kind of bounce around, as, again, regular listeners know. But just again, who am I? Attorney Doug Clark, Clark Law Firm, been doing the radio show since August of 2010. I represent landowners and only landowners. I've done hundreds and hundreds of gas leases, hundreds of pipeline and water line agreements, very involved in royalty litigation, royalty deductions, estate planning, more and more, and I see my focus directing even more and more to estate planning as I go forward, gas lease amendments and modifications, unitization issues. Do you have a claim of bad faith unitization? Many people think they do. Unfortunately, many times they're not correct, but sometimes they are. And so if you feel that you have a claim and you want to explore that, we do those things as well, and give you honest, straightforward advice. Like I said before, honesty is the key. If you don't have a claim, say, look, in my opinion, you don't have a claim. No stringing along, none of those things. Treat people like you want to be treated. Surface use agreements, have done many of those, many right now, meter sites, compressor stations, any contract related to Marcellus Shale, as well as much more. Anything regarding natural gas development, we're here to assist you. And you can contact me anytime at 570-307-0702, 570-307-0702. And regardless of where you are in the state, people, regular listeners know I say, I've had clients in Alaska, California, Texas, India, London, and Micronesia. And if you don't know where that is and have to look it up, I'm going to tell you, I had to do the same thing. So, all right, I'm up against it as I always am. You're listening to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm excited about today's show. Got a lot of energy here today, so I look forward to the next segment. I hope you will as well. Be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And, I said I'm kind of fired up today. Got a lot of energy. A little fired up in general, and I really think, I kind of know what's got me all fired up. Doing all this work on the websites, really getting back into the sites, updating them, and embarrassingly, I have to say, I think it was overdue. So I'm really glad I'm doing this. I'm really excited about it. It's going to have a new look, a new feel. Really excited about it, and it's kind of re-energized me as I go and I'm writing all this new text for the websites, trying to get this information out there. And I swear, if there was a big rock somewhere where I could stand and scream certain things out to landowners where people would come and listen, I would do that, because I start typing and I'm writing and I'm working on these, talking about these top 10 biggest mistakes landowners make, and I find myself, I can write books. I can sit there and write a book about these things, and it's just so frustrating because I see that landowners continue to make these mistakes, and it's just about trying to get this word and information out to people to get them thinking. One of the things that I think that landowners get worried about, and I talk about this before, and I think about it when I was a kid. My mother and father, I never even heard the term lawyer or attorney unless it was on TV. I do not believe in my entire lifetime at my house, and from 0 to 18, that I know of, that my family, my parents, ever went to a lawyer. They didn't have a lawyer. They never went to a lawyer. And, sure enough, too, my grandparents had signed a gas lease on their property out in Armstrong County in the western part of the state. Now, back then, I think they signed for $5 or less per acre, and it was a standard, that's what people did then. And, again, at that time, it didn't really make sense to get a lawyer in most cases, and people couldn't afford it, and you certainly don't want to have a higher legal fee than you do in what money you're getting. But that's that mentality of, hey, never needed a lawyer, haven't had a lawyer. Maybe there's some fear or apprehension, more apprehension than fear to contact an attorney. But I'm going to tell you, whether it's me or somebody else, I say that so many times, and I mean it. I really do mean it. If it's not me, make it somebody who is experienced and understands your circumstances, that understands how to maximize these agreements to your benefit. Look, I'd love to help you, but if it's not me, it's not me. But please make sure it is somebody, and somebody that understands what they're doing, because people are signing these agreements and literally missing out on tens of thousands and hundreds of thousands of dollars. Also, missing out on the ability to limit what a company can do on your property. If they can operate on your property, where can they operate? How much influence can you have in that process? Those are important things. And a good attorney is going to sit down, they're going to make sure that they're getting you the best possible agreement. Now, in every case, in almost every case, no one's going to be 100% happy. Sometimes people are, but just generally speaking, there are things that you may want that you just can't get. But it's important to understand that you've tried, or, okay, well, I can't get these addendum terms or these provisions. Well, why? Okay, and then what does that mean for me? So you really need to be exploring all of these things. One of the things I found when I'm doing this website that repeatedly comes up is the landman works for the gas or pipeline company, not for you, the landowner. I cannot say that enough, because these landmen are very good. They're very good at their jobs. And okay, they got a job. We respect that. But everybody has to understand what their job is. And as a landowner, you need to understand that that person sitting down at your table or knocking on your door is essentially trying to sell you something, to get you to sign a document that they have. And the quicker they want you to sign that document, which is almost always that moment, you need to be aware. Red flags should be flying up everywhere. Who is going to sign a major industrial contract with the landman in a day or a couple days, or especially the day they come out there? And when you read this contract, it's going to be glossed over. They're not going to explain to you all the different pitfalls and all the different potential problems for you if you sign the agreement. They're going to talk about all the advantages. Well, we can't get your royalties unless we get pipelines in the ground to get that gas to market. Very, very true. But at the same time, that doesn't mean that you should get a very bad pipeline agreement and they should get over on you with a very poor document. And then you suffer for a very long time. Here's the thing. Pipeline agreements nowadays, they started $10, $15 a foot. Some companies do it per acre of the area of the pipeline. But overall, say $10, $15 a foot. Now, routinely at $25, $30, and more per foot. In some cases, companies have paid in excess of $100 or even more than $100 per foot. And I have seen numbers on many occasions go from a $15,000 offer to a $100,000 offer. I've seen it multiple times, and even more, from $50,000 to $200,000. You have to understand what your circumstances are. Not one time has a landman gone to the landowner and said, listen, I'm going to offer you here, I'm authorized to offer you $25,000. But hey, if you ask for 75 and you ask for terms that are going to limit the size of the right-of-way, you're going to ask that we can't put telephone poles, electric lines, or cables, that we're limited to 1 or 2 pipelines, that this agreement is going to terminate in a certain time if we don't use it. Well, if you ask for all those and $100,000, you can have that. Well, that doesn't occur. You know what, though? But if you have a good attorney and they understand your leverage and your situation, and I promise you, make no mistake that this doesn't happen in every occasion, but you look at your situation and you figure this out, and your attorney or somebody who's skilled and experienced can say, hey, look, there's something here. Here's what we think we can do, and let's talk about this process and see what number may work for you and how you want to handle this. Well, you may come out of this with a $100,000 agreement and all the other items that I talked about, versus, oh, hey, landowner, I'm the landman, I'm real pro landowner. Listen, I haven't met one landowner that goes out to the company or goes out to the land, or I'm sorry, I haven't met one landman who has gone out to a landowner and say, hey, Mr. Landowner, I'm going to be honest, I'm real pro company. I'm all about the company, and I want to try to get you the worst agreement for you, but the best agreement for the company. That's what I'm here to do. I haven't ever heard that. But what I have heard is, oh, hey, Mr. Landowner, I'm the landman, but you know what? I'm a real pro landowner. I'm all about the landowner. This company's bad. We need to make sure you're protected. I'm all about the landowner. Well, if the company's so bad and you're all about the landowner, then why are you working for the company out there asking the landowner to sign a form boilerplate agreement at the lowest possible compensation offer this company will make? Why would you be doing that if you are pro landowner? If you are pro landowner, then you would explain to the landowner all the different pitfalls and problems with the agreement that you have in front of them, and you would say to them, hey, look, I wouldn't sign this. You need to talk to somebody who understands this, who can explain the legal ramifications. There may be additional compensation that's available. There is almost certainly additional terms that are available that are going to result in less impact on your property and probably greater compensation if there's future activities. So do they say that to you? Of course they don't. Of course they don't. So everybody out there, and it just continues to happen. Landowners will call, oh boy, that landman was really nice. He tried to get these terms, but he couldn't, so I guess we can't get them. Well, landowner, remember, he doesn't work for you, or she doesn't work for you. They work for the company. And if they're so pro-landowner, then why aren't they telling you all these other things? So landowners are still out there, all over, probably literally every single day, falling into these traps of the tricks of the trade. This has been going on for years and years and years, where these landmen, they have very experience in dealing with landowners and personalities, and they'll mold and shape and take their personality in the direction it needs to be in order to befriend you and to get you to sign the document. You know, it's so funny. Out here, like, there'll be every once in a while, there's like a certain landman who will come up and talk to a landowner, and they say, oh yeah, the landman Joe, you know, oh yeah, he used to be in Army Special Forces. And then I'll get another call from somebody, oh yeah, the landman, oh Joe, yeah, you know, he was a great guy, he was in Army Special Forces. And then another guy calls and says, hey Joe, that landman was Joe, oh boy, I really liked him, he's a former Army Special Forces guy, great guy. And it's like they have it's almost like a script or a routine, and they want to tell you all about their history. And again, it's just to be aware of what's going on here, that it's almost like a script. You're getting the script, the guy down the road's getting a script. They're going to tell you and sell you on what has worked for them in the past. They want you to like them. They want you to believe that they're representing your interests. Remember, ask them to pull out their business card. Ask them to show you their business card and see if your name appears anywhere on it. No. They represent the company, and they are there to get the company the best agreement possible for the company. Otherwise, these jobs have a lot of turnover. Once an area is kind of leased out, those leasing landmen go somewhere else. So if there's 20 landmen working on a project now, and they're going to a different project and they only need 10 landmen there, who's going to get laid off? Who's going to get assigned that project? Are they going to give that one of those 10 jobs to the landman who's all pro landowner, who got the landowners the best possible agreement? Or are they going to give them to the company or to the landman who was out there getting the best possible agreements for the company and getting landowners to sign? I will not even answer that question. I'll leave that to you. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 a.m. And yeah, I say about I have scripts and I have ideas, and yeah, I got just sidetracked here with the whole landman thing, and I've gone on those rants. But it's one of these things where literally it's happening still every single day. Every single day, landowners are like, boy, that landman was really nice. Or, boy, they need to sign this agreement because they're going to get me royalties. I'm going to get money like next year. I'm going to be all these promises of future riches. I'm going to be a millionaire. Well, just look around. That's not what's occurring everywhere. Some people are benefiting very well, but they tell you, hey, we need to get this. We need to get these pipelines in the ground. We're going to make you money. We're going to get you money. But the agreement that they present to you to sign says that they don't even have to put the pipelines in the ground or start working or even pay you for 2, 3, 4, 5 years, sometimes more. And so ask them this question. Hey, if this is such a hurry, you need to get this done right away, instead of having a 3-year or 5-year window in which to start these operations, why don't we make it 1? Why don't we make it 2? Well, you don't know, we don't know what's going on. Well, you just told me 10 minutes ago that you wanted to get these lines in the ground next year and start getting me money. All right, I'm going to let this go. I apologize, but I do get fired up. And again, it's not that the landmen are bad people by any means. There's landmen I really, really like, and most are courteous and fine to deal with, but that's their job. We need to know, you need to know and understand their job and their role in this process. You have to understand that. It's not to beat them up as individuals. They have a job to do and they're doing it the best they can. But you have to understand that that's the job that they have. When you go in to buy a used car, You understand that the guy you're speaking with to sell you the used car is trying to sell you this car. Understand, it's not necessarily the same thing, but in some ways it's the same or similar. They're trying to sell you on signing this agreement. How great it's going to be for you. Well, very rarely are these agreements nothing but roses for the landowner. Make sure, whether it's me or somebody else, that you're getting this assistance and advice. It is critical, and people keep making mistakes, and we want to avoid that. All right, I'm way past yet again. I am Attorney Doug Clark. You are listening to All Things Marcellus here every Sunday from 8 to 9 a.m., and I'm going to be right back. I'm going to talk some leasing issues. I'm going to get off the land, man. Talk some leasing issues here right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Remember, you can always contact me if you'd like directly at 570-307-0702. That's 570-307-0702. We're here every Sunday from 8 to 9 a.m. And remember to go check out pagasleaseattorney.com, pipelineattorney.com. Great information for you as landowners, and we are going live soon. I'm going to put a new target. I'm going to say by the 1st of January of 2015, maybe sooner. I certainly can promise I'm trying to make it sooner. We're going to be live with the new gas site and shortly thereafter with the pipeline site, but pagasleaseattorney.com. You should check it out now and go back, keep checking. Very excited. I'm writing. I'm like a mad scientist here in the evenings, in the morning, writing new texts, working on the site, and it's pretty fun. I'm enjoying it. It's just about getting the time. So check out the websites. We're going to be posting, as we have been, the radio show since August of 2010 up on the websites at pagasleaseattorney.com. Also check out pipelineattorney.com. All right, switching gears now. Leaving the land, man. Leaving my little script stuff. Let's talk about addendum terms and gas leases. And here's what I want to talk about. I say talk about addendum terms. Well, what we see is, and I've been doing more leasing. I think I said before, I have like a leasing drawer of files, and it's starting to kind of, grow and grow and grow. And so we're seeing more leasing in northeastern part of the state, the southwestern part of the state, and other areas as well. I've talked a lot about Tioga County recently. I had a new client from Westmoreland County just this past week for a gas lease. So we're seeing a lot more leasing activity in recent times. So we see that and we say, okay, what's going on? I talked earlier about how these markets are changing, that you can't always get what you used to be able to get, but in some areas, surprisingly, you can do very well and get some additional addendum terms. But even in areas where it's a tough fight, usually, in almost all cases, almost every single case, we're able to do something or things that are going to benefit you as the landowner. That's certainly going to make it worth your while to have an attorney who knows what they're doing to get you the best possible agreement, to increase it where it can be increased. Sometimes the increase isn't as big as we'd like. Other times the increase and the benefit is substantial. And you have to understand your circumstances. And if it's a situation where you're presented with an offer where, say, for example, I know we're just really going to have limitations on what we can do here. Well, you take that history. You take that history with this particular company. You take your history and knowledge from dealing with many other companies, and you give the best advice to the landowner and say, look, here's what this company does. And we need to understand this. We need to get in and out, get you the best possible agreement, and then move on. So you're not running up legal expenses and not seeing a benefit for that. Now, in other areas, we know, hey, this company will negotiate and we can do some different things. So let's talk about this. What's important to you? What can we possibly do? And let's make sure that we're maximizing your situation with this company in your case. And a good attorney is going to know right at the beginning, hey, what are we going to be able to do here? What's realistic? You also, many times, there's the conversation with the landowner to say, I believe me. I do understand these terms. I do understand why you would want certain things, but I'm going to tell you that I don't see the company agreeing to these things at this time, and here's the reasons why. we can go ahead and ask for them. Or maybe we want to kind of modify what we're going to ask for because maybe there's some other terms that are really important. And if we use history and modify the way we present this, we can get you the best possible agreement. But if we just, if you just go on the internet and copy 50 addendums and throw them out there, well, you may just end up not even getting anything considered. So, like I started in the first part of the show saying that representation for everything, oil and gas leases, pipeline agreements, surface agreements, all of these types of agreements, compressor, meter site, above ground facilities. Representation today is very particular, and it's a lot different to what it used to be back when there was all of this development. And knowledge and experience is going to guarantee that you get the best agreement you can in your circumstance. And just going out and looking at or reading about message boards and things like that, what people obtained in the past, or maybe even didn't obtain, but they just claim they did, that's not going to help you. You need today's advice by somebody who has the experience and history to give you that best advice, whether it's me or somebody else. Look, you can always contact me. I have a passion for what I do. I love to represent landowners. I want to make sure that we're evening this playing field as much as possible. I want to make sure that every one of my clients gets the best possible agreement that we can obtain. But whether it's me or somebody else, get some assistance. Don't be taken advantage of. And every day, people are being taken advantage of. And I don't know if they're afraid. There's this apprehension to get assistance. Get assistance. I promise you, a good attorney is going to make it way to your benefit that you contacted them. It's going to be a good thing for you that you contacted that person. And if they can't help you, they're going to tell you they can't help you. And you need to have somebody you're comfortable with. It's so important today. It's so very important. More important than even what it used to be when people were kind of signing not only a boilerplate lease, but boilerplate addendum terms. Well, now it's not the same. So you need to make sure you're maximizing your situation. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m. And here we finally go talk about some addendum terms. So, okay, landowners are offered new leases. And I'm seeing some situations where there's a lot of unique terms out there. We're seeing some smaller companies come in and try to acquire acreage, and we look at it and say, well, why are they acquiring this? And a lot of times they're acquiring it in hopes that they can assign, or what people call sometimes flip, or transfer to other companies. And we want to look at all these things. Is this a company that's going to actually drill? Is this a company that's just looking to cut a deal on your lease and transfer it over to another company? And if that's the case, you got to be super careful because there's often a lot of loopholes in these agreements to allow this company to back out of the deal. So very important. If you're dealing with a company that you never heard of, if you're dealing with a company and you go and you look online and you say, they were just created a year ago, 2 years ago. Well, you need to learn more. You need to get more history. You need to get more history that you can dig up, but also history maybe that your attorney knows that can provide to you. So you have to be very careful. So we're seeing a lot of different types of offers and different addendum terms. I'm just going to go through some terms and give you some ideas of things which, just classic pitfalls. And when I say pitfalls and I say classic, some of them are very common, some of them aren't so common, but it's an idea of what's occurring out there today. And it's occurring all the time. So here's like one example. In this particular case, the landowner it was very important to them that they were guaranteed that they were going to receive full payment. What I mean by that is we're seeing more of, in some areas, instead of getting a bonus payment, I'll make up a number of $1,000 within 120 days that you sign the lease, or within 90 days you get $1,000 per acre. Well, a lot of companies are starting, especially in the central part and western part of the state, they have some kind of more complicated offers on how they're paying and splitting payments. You got to be very careful about that. the landman is going to want to point to the big number, but the reality is you may never get that big number. You need to understand that. You need to understand what may occur in order for you not to get that big number, and are you guaranteed? And you need to understand that, because again, people are thinking, oh, I'm going to get $2,000, $3,000, $4,000 per acre. And the reality is that's very unlikely. You need to understand your situation. So in this case, the landowner was very concerned and wanted to make sure that they were guaranteed all the money, but also wanted to set it up that they were going to get, say, half of the money say this year and half of the money next year for tax purposes. There's a whole other show on that. Okay, whole other show. If you're splitting that, you need to make sure you got to be careful. I mean, you got to be careful. That's a whole other show. But please, if you're splitting payments, be careful, because if you get one payment, maybe the company surrenders or gives up the lease and you never get another one. It may be right, may not be right. It's a unique situation and you need to be careful. Okay, so in this case, the landowner is very excited because the lease says, or the addendum says, we're going to give you half of this money in 2014. Then we're going to give you the other half of the money in January of 2015. Well, that's a good deal, we think. Okay, and landowner's like, okay, this is great. I'm going to get half in 2014, half in January of 2015. So it's meeting my goals of, trying to do this for tax purposes, but also it's nice because you might get the one payment in December, you might get it December 20th, and the next payment the first week of January. So you don't have that big year or more gap where maybe the company does surrender the lease and doesn't pay. So that's a much better situation. If you're going to split payments, splitting them between December and January, within a 60-day period, it makes a lot more sense than spreading it out over 2 separate years or even multiple years. And whenever the calendar time, obviously if you were going to get paid in January of one year and January of the next year, you got 12 months as opposed to this little 1 month gap. So that makes it more palatable, but doesn't mean that it's right for you. Okay, but in any event, in this case, hey, great. I'm going to get half the money in December 2014. I'm going to get half the money in January 2015. That's a big motivator to me. However, so and very often there's howevers, and that's what nobody's talking about, and that's what the landman's not telling you. However, so it says we're going to make these payments December and January, but then it says that the landowner understands and agrees that the signing bonus payment will not be released until title is cleared and certified. Okay, what do we have here again? We have an agreement that says, I'm going to give you one half in December. I'm going to give you the other half of bonus in January. Next line says, landowner understands and agrees that the signing bonus payment will not be released until title is cleared and certified. Well, what does that mean? Well, I'll tell you what it means. You're sure as heck not guaranteed that you're going to get these payments in December and January. And in fact, what if there's a title issue that comes up? What if that title issue lasts a very long time? Well, you're not going to get paid anything until that title issue is cleared. And what if the company, what if they're slow in doing their title? What if they don't get done with the title in December of 2014? Well, what happens then? They're telling you have these inconsistent statements right after each other. Well, what does that mean? So when I talked to this landowner, I said, listen, I understand what your goal is here. I understand what you want to do, but you need to understand that that's not guaranteed here. And you need to understand whether you're comfortable with that or can we guarantee it? And that's one of those questions where, well, you may ask the company and the company turns around and says, well, no, we can't do it. Well, if they can't do it, that means you might not get paid in the way that you thought you were going to get paid. And that's just one small example. I'm going to go through several more here in the last segment. So things like this are happening all the time, and the landowner's like, oh, this is great. I'm going to get a check in December. first off, they may never get a check. And second, there's no guarantee that title, when is title going to clear and that they're going to get this payment. And there's ways around that, but it's certainly not covered in what's going on here in the agreement this landowner has. I am Attorney Doug Clark. This is All Things Marcellus. I'm going to be right back. You can listen, remember, every Sunday from 8 to 9 a.m. and also pagasleaseattorney.com. Go on YouTube, type in All Things Marcellus. I'm going to be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm, here every Sunday from 8 to 9 a.m. I got a short segment here, so I want to get to this. Okay, we got talking about addendum terms. These are examples and things to be thinking about and things that are occurring, and some things to make you think about, okay, do I understand everything that's going on here? Here we go. Here's another part of this this addendum and this offer to a landowner. They provided to me to review, and we did a consultation, went over these things. One of the big things for this particular client landowner was eliminating any roadways or pipelines, well pads, or dictating where these locations were to occur. So sometimes, in some cases, you can actually have maps attached to a lease saying, okay, you can operate here, or here's where the roadway can be. Here's where a pipeline can be. Here's where you can have a well pad. That's not, it's not something that's extremely common, but certainly something we've done in the past. So in this particular case, there's been a map or these promises. Okay, well here, we definitely want to operate in your property. Here's what we want to do. Well, comes time then for the agreement. Well, there's no map now, and I wasn't involved in this part of the process, but there's no map. So what there is, though, is, and they say, hey, yeah, landowner, you're okay, we got you all covered. So here's some of the problems. Here we got this language saying that the prior to any of these operations, that the company and the landowner will agree in writing to the location of all facilities contained either on the well pad, where wells could be, where roadways, pipelines, or any other facilities on the property. So you have to agree in writing. Then it also goes on to put maximum sizes of these different items that could be on the property. Then it goes on to say that we're also going to set a price that we can drill off of your pad into other units that you're not participating in. So that typically isn't allowed under the lease agreement, but this one's crafted that it is allowed. This landowner doesn't know the difference. They think, okay, well, this is normal. Well, it's not normal. And if it's going to occur, then there should be more of a benefit than what they're paying. And remember, if you're going to have these other pad or wells on your pad, you're going to have more activity. It's, if you're going to agree to it, hey, that's great, but it should be something you're aware of, and that you consciously say, okay, I want to do this, and whether it be for the money or whatever reason, there should be a reason. But getting back to, this landowner thinks, okay, I have them. I have to agree where anything is going to be in writing. Then it goes on to say, though, and this is where you have to be very careful. You have to really dissect these agreements. And frankly, a lot of times there's a lot of words there. So you have to understand what one section does, what another section does. There's contract language that we put in to say, okay, well, despite anything else that may contradict to this provision here or this language, this is the language it's going to control. So in this case, we say, okay, well, this sounds great. The landowner has to approve anything in writing. This is in one section of the agreement. That sounds great. That's wonderful. You have to approve it. Then it goes on to say, though, in a different section, that the location of any of these wells, roads, pipelines, any other surface activity has to be approved. We said shall be approved by this landowner or one of their legal representatives in writing. Okay, again, well, isn't that kind of what I just read? Well, yeah, it is pretty much. Wording's a little different, but essentially the same. But the key words here then, the next sentence, such approval shall not be unreasonably withheld, conditioned, or delayed. So what does that mean? Well, if you only read the one section, you would say, hey, this is great. They need my approval. If I don't like it, I don't have to get it or give it. But then you go into a page or two later, you see, okay, well, all of these locations I have to potentially agree to because I can't be unreasonable. And what's even more disturbing in this particular case is there's some other language about allowing roadways that go across your property to well sites that do not produce gas from your property. And what happens is we get these kind of inconsistent statements. So this particular case, and this is very complicated to explain, but I'm going to just kind of give the overview. In this case, it appears there's an appearance in one portion of the agreement that says, hey, well, if you're going to have a roadway that's going to go to a neighboring property and I'm not going to benefit from this roadway, well, I have the ability to sign and say no, or not sign and say no. However, the lease itself gives the general authority for such a roadway, which is unusual but is happening more and more. So once the lease gives that authority, and then you have another section of the agreement saying, well, you have to sign off on and approve it. Okay, well, that's good because I just won't sign. But then pages later, you have the statement saying that any roadways have to be approved by you, but you can't unreasonably withhold your approval. That can result in a disaster. It may not seem like much to a lot of people at this time when nothing's going on, but I'll tell you, I talk to the people when all of a sudden the company wants to come in, put a roadway, divide your property in half, and essentially make it useless for any future development, to impact your farming, to impact your hunting, whatever that case may be. And it could have been prevented if you just did it the right way. Or you might have saw this coming if you were informed and understood what you were dealing with. So these tricks are occurring all the time. Also, inconsistencies which aren't being fixed or rectified or remedied. We see these inconsistencies in these documents, and they can be fixed if you know what you're doing, but the landman who's working for the company isn't fixing these for you. You need to get this fixed and remedied, or you may have a big problem. I am Attorney Doug Clark. This is All Things Marcellus. Again, I'm here every Sunday from 8 to 9. And the last thing, okay, I've got a few minutes left, and I think I can get to this. One of the things that clients want, or landowners want to say, hey, I want to have all my property in a unit. I want to guarantee I'm going to all be in a unit. I couldn't agree more. That's a wonderful thing. We'd like to do that. But what if a company's going to say, and rarely will they agree to this, but if they will and say, okay, well, yeah, we're going to put all your property in a unit, well, the next question becomes, when? And here's some language. It is agreed between the company and the landowner that the lease that this lease can be unitized with other properties. And here's it gets very interesting. The parties agree that if any part of this property is included in a unit, then 100% of the landowner's property shall be included in one or more drilling units. Well, what does that mean? What does that mean? And so here's we have a lease where, in these leases, if you have any of your property included in this unit and there's drilling, that holds your entire lease. So if you have 100 acres and 5 acres are placed in a drilling unit within, say, a 5-year term, so now you're held under this lease, it's not going to terminate. Well, this provision says if they put any in a unit, they'll put all in a unit, but it doesn't define a time frame. So at 5 years, if only 5 of your acres of your 100 is in a unit, has the company violated this agreement? I don't think so. Well, what about 10 years? What about 15 years? What about if they put 50 acres in a unit in 15 years and say, oh, we're going to put more in? Do you now have to sue them? Or could you have taken care of all of this? If the company was agreeable to unitize your property, could you say, hey, we want to guarantee that if you put any of my property in within 5 years, say within 10 years, all of it has to be unitized. Well, and if it's not all unitized, well, what happens? Well, Pew clause says that the property that's not unitized would revert back to you. Okay, that's fine, but a preferred clause would be, well, if you don't unitize at all, then if I want to, I can cancel the whole lease. Well, if there's a drill underneath you, a well underneath you, the company isn't going to want to cancel that lease. So you're going to have a lot of leverage there. So it's a much better provision to have this 100% unitized within a certain time frame versus a pew clause, which people think is a great provision, but nowadays it's not so powerful. I am Attorney Doug Clark. I'm up against it. I hope everyone has a wonderful week. There's plenty more to talk about in this, so make sure you keep staying tuned. Again, I am Attorney Doug Clark. You're listening to All Things Marcellus. Have a wonderful week, everyone, and I'll be back next Sunday from 8 to 9.